All right then, so good afternoon everybody and welcome to today's HR Exchange. Today we are going to be looking at performance management under the new unfair dismissal rules. So my name is Alex Herwood, I'm the Head of Employment and a Solicitor at Bhayani Law, and I'm joined by Hasti Ascani, who is an employment lawyer at Bhayani Law, and she'll be talking to us a little bit later on performance management and capability. So just before we start, just to let you know, this session will be recorded and shared publicly. So please be mindful not to share any confidential information in the main session. If you would like to discuss anything confidentially with us, then please email us at hello@bhayanilaw.co.uk. So in relation to questions then, if you have any questions throughout the session, please just pop them in the chat box and Hasti will be managing that chat box, and we'll aim to answer as many as we can during the session. If we don't get round to them, please just make a note of your question and you can email it to us at hello@bhayanilaw.co.uk and we will get back to you as soon as we can. So just a little bit about the HR Exchange. So this is something we do to support employers across the entire employee life cycle. Okay, so the idea is that we're offering you an opportunity to gain valuable advice and information from employment and HR professionals. So we hope that you get some good takeaways from this session. So on screen now, you can see that this has been created really to show an employee's lifestyle journey. So we can help from anything from recruitment all the way through to termination and really anything in between. So we offer all those services and we also offer bespoke training courses too. So what will we be covering today? So today we're going to be focusing on the points on screen. So what the reduced qualifying period means in practice. We're going to be looking at managing poor performance from day one. We're going to be using probation effectively as a risk management tool and looking at what that looks like. We're going to be looking at from probation to capability and what that looks like. We're going to be looking at the importance of objectives, feedback and documentation, and ensuring that we're maintaining those standards while we're reducing that risk. Okay, so we're going to take each point in turn and hopefully you'll get some good pointers from it. So just before we start then, I just wanted to kind of remind you of the three things that we need to be thinking about when we're managing these changes under the Employment Rights Act 25. Okay, so we want to be looking at training and awareness. We want to be looking at policies and processes. And we also want to be looking at that engagement, so that engagement with your workforce. So if we're going to break that down, firstly, if we're looking at training and awareness, what that means is we're ensuring that the people dealing with the issues and making those decisions are fully informed of what's changed and what's changed under the ERA. Okay, so for example, if they're dealing with, I don't know, a flexible working request, they'll need to understand the law and how it's changed, and they'll have to have read that new policy and know what processes are expected of them. In relation to policies and processes, so the next thing, so it goes without saying, doesn't it, that the Employment Rights Act is going to require many of our policies to be changed and updated. Sometimes this is just going to be little tweaks, and sometimes we'll have to make quite significant changes. So we just need to make sure that our policies are updated, in time for the changes. Obviously, a lot of the changes have already come in, and then the people, your employees, know how to use them. And then employee engagement. We know that as a result, unfortunately, of the changes, things are going to feel a little harder for businesses. So one of the best ways that employers can cope with this is to keep those employees on side, getting them engaged as much as possible, and kind of able to kind of move with the way that you're moving. So, employment tribunals. I'm not sure whether any of you have had any experience with employment tribunal claims kind of landing on your desks. Hopefully not, but I'm sure some of you have. Employment tribunal claims, as we know, can typically include, unfair dismissal, discrimination, sexual harassment, unlawful deduction of wages, unpaid holiday, redundancy issues, TUPE, and then potentially whistleblowing claims where people have been subject to a detriment, or they allegedly been subjected to a detriment because they've blown the whistle and subsequently been dismissed. Okay, so those are the kind of claims that we see in tribunals. But today we're going to be focusing on unfair dismissal and this reform that's coming in, which effectively means that the qualifying period for bringing an unfair dismissal claim is going to be reduced from 2 years to 6 months. Okay, and that's going to be from the 1st of January next year. So, excuse me. So what is the current situation then? So we know that employees have to have, at present, 2 years continuous service to be able to claim ordinary unfair dismissal. So, you know, there's limited protection in terms of obviously unfair dismissal during that first 2 years. Yes, they have day one rights to discrimination, whistleblowing, automatic unfair dismissal. But in relation to an unfair dismissal perspective, they have to acquire that 2 years service. So employers need to show a fair reason and a fair process once that qualifying period has been met. So what's changing then? So that qualifying period, like I've said, is going to be reduced from 2 years to 6 months. But employers still need to show a fair reason and a fair process once that qualifying period is met. So what does this mean then? So this means that employees will gain ordinary unfair dismissal protection much earlier on in that employee relationship. So this doesn't mean, for example, that employers can't dismiss employees during or after that probation. Employers absolutely will still be able to do this under kind of managing that performance or conduct issues or, you know, unsuitable hires. However, the key difference here is that employers will increasingly need to demonstrate that fair reason for dismissal and that fair process at a much earlier stage than before. So, you know, in turn, this is creating a major kind of practical shift for businesses, because many organisations currently do not apply particularly structured or formal processes early on in probation and in the early months of employment. So that's what we're going to be looking at today. But before we go into that and those probationary periods, etc., we need to be having a little look at what happens beforehand. So this is obviously pertains to recruitment, and you know, I really think it's never been more important, and recruitment is going to be, you know, something that we need to really bear in mind now when we take on those new recruits. So it's about really shifting the mindset of the employers. So, you know, historically, many businesses have viewed that recruitment process primarily as a kind of an operational exercise. You know, they're filling those vacancies quickly. Are they ensuring the right technical skills, and they'll be addressing that immediate business need. But under the Employment Rights Act reform, recruitment becomes more than that, because it becomes a significant legal risk management exercise. And why is that? Well, because employers will no longer have the same flexibility to, you know, try someone out, see how they go, and then exit them relatively easily if things don't work out. With this reduction in unfair dismissal qualifying period and the increased kind of scrutiny around the dismissal, around that probationary dismissals, poor recruitment decisions become far more costly for an employer. So what does that mean in terms of from a practical sense? So employers can no longer rely on those kind of informal exits, the vague, this person's just not right explanation, delaying those difficult conversations until the end of probation. That absolutely just can't happen anymore. Instead, organisations need to get that recruitment decision right from the outset. So this means really shifting the focus towards the stronger recruitment processes, better assessments of behaviours and values, which is a super key one, clear onboarding, and earlier performance management. So one of the key things that we encourage kind of our clients and employers to think about is whether they are recruiting purely for kind of technical competence or whether they are genuinely assessing the long-term suitability of that person for the organisation. Because often what we see is that the biggest performance issues aren't caused by, you know, potentially that lack of technical skill, but they arise from things like poor attitude, an inability to work as a team, resistance to kind of constructive criticism or feedback, a cultural misalignment, or just simply some behavioural issues. So these issues are much often harder to manage once that employment relationship has started. And so what these reforms are doing is effectively kind of raising the stakes for those who are recruiting, so those managers that are recruiting for those positions. So because I think what we need to bear in mind now is that a kind of a poor recruitment decision can now lead to, an increased legal exposure, lengthy performance management processes, employee relation difficulties, and significant management time. So ultimately, the organisations that adapt best to these reforms are likely to be those that become more deliberate and strategic in how they recruit and manage people from day one. So I think a key message here is really that, a poor recruitment decision is no longer simply just an operational issue, okay? It's now a significantly greater legal and financial risk. Excuse me 1 second. Okay, so why recruitment is likely to be more costly under the Employment Rights Act 25. So this slide is building on the previous points. Employers currently have a degree of flexibility during that first 2 years of employment. So if a new hire clearly was not suitable, employers can end the relationship, the employment relationship, relatively quickly, with limited legal exposure, provided obviously there's no discrimination or whistleblowing automatically unfair reasons. So that flexibility is going to kind of reduce substantially. And something we just need to bear in mind here is, so the reforms are coming in on the 1st of January, but that doesn't mean that those that are recruited from the 1st of January will fall under the new reform. It actually means anybody recruited effectively from the end of June, so next month, will be able to take that claim on the 1st of January. So it's really important that you're applying this. Yes, we're talking about the 1st of January 2027. But it's actually thinking about it right now, because everybody you take on now or from the end of June are going to have that right to be able to pursue a claim against you as an employer excuse me, from the 1st of January. So under the new framework, employers are going to face increased scrutiny much earlier on in that employment relationship, and like I said, particularly in relation to those probationary periods. So that means that poor hiring decisions can quickly kind of evolve into legal risks, disruption for the workforce, burden on management in terms of time, and potential reputational issues. So one of the first practical consequences is the increased likelihood of disputes during the probations. So employees are becoming increasingly aware of their right, and where concerns are poorly communicated or managed, or processes are inconsistent, for example, employers are likely to face more grievances, allegations of unfairness. Obviously, you've got the discrimination complaints potentially, or any other tribunal claim. The other significant issue is unfair dismissal exposure. So once employees gain protection earlier, employers will need to show not only that there was a genuine concern, but also that the expectations were clear when they started, that the feedback they were given was clear, that they were offered support to improve, which Hasti will be talking about a bit later, and that a fair process was followed. So that requires kind of a significantly more structured way of dealing with it than potentially you are doing now with your probationary periods. So even under the current scheme, comments such as comments such as kind of they're not right, they don't fit the culture, they don't seem to be committed. We know that they can be problematic now if they're unsupported or potentially linked to protected characteristics. But these reforms are likely to increase that scrutiny around these issues, because dismissals during that early employment will attract kind of a greater attention. So I suppose there's a real kind of commercial impact there. So poor recruitment decisions then are going to create significant management and HR burdens, We're going to potentially be looking at, repeated meetings. We need to be looking at that documentation, the training, the supervision, the conflict management, and any performance monitoring. And even where kind of a claim never materializes, the internal cost of the organization can be substantial, in terms of what you're having to get your management team to do. Then, of course, those costs can then go external. So you're looking at those legal fees. If they submit a claim, then you've got the tribunal preparation, the potential reputational damage, settlement discussions, etc. So this is kind of why the traditional reliance on short service dismissals and, informal exits or vague, not the right fit explanations become increasingly risky. So in tribunals, an employee will expect employers to demonstrate that evidence. So employers need to move forward to a much more kind of objective, evidence-based approach to recruitment and probation management. So ultimately, I think what I'm saying here is the message is that prevention is becoming far more important than the cure. So investing more time and structure at that recruitment stage is likely to save your organization a significant cost and risk later down the line. So just a little poll for you here. No, let's go back one. So what is the most important quality you look for in a new hire? And I'm hoping Alice is going to put the poll up so we can see. No.
Yep, the poll's live.
Yeah, it's live. Okay, lovely. I can't see that in there. Okay, there we are. I can see it. All right, so lots of you have contributed, which is fantastic. So we've got technical ability, attitude, cultural alignment, communication skills, and adaptability. Okay, so having a little look at the scores coming in, a lot of you are saying cultural alignment, and attitude and technical ability. It's going cultural alignment and attitude and technical ability kind of are second, but it's really great to see that a lot of you are saying cultural alignment, because I really strongly believe that, it's not just, and this is what this slide is saying, we're not just recruiting for those skills now, okay? It's about looking at those values and how does that employee align with the values of your organization. So recruitment processes are often prioritized in terms of qualification, experience, technical expertise, or sector knowledge. And of course, we know those things are important. Of course they are. But technical competence alone, just by itself, is really not going to be enough anymore. And I say this because the new framework, or under the new framework, employers are taking on a greater risk when they hire someone who might not align with the organization's culture or behaviors or expectations. So in practice, many of the most difficult employee relation issues are not caused by a lack of technical skill. They arise because, those individuals may, for example, struggle to work collaboratively, working as part of a team. They may be resisting that feedback. They might create conflict within teams, fail to take accountability for their actions, behaving consistently within organizational values. And these behavioral issues are often significantly harder to manage than technical performance concerns. And this is why employers should increasingly focus on recruiting people that align with their values and their organizational culture, are demonstrating the right behaviors, and are able to communicate professionally and show that ability to adapt and work constructively with others. So another important point to emphasize is that values-based recruitment doesn't mean recruiting people that they're all the same as us, because that would be really boring and wouldn't really work. But it's not about that. It's not about people fitting in socially or personally. It's just about ensuring that employees understand and demonstrate the professional behaviors of the organization and what they expect. So again, like I've just said, accountability, professionalism, collaboration, the openness to feedback. And the reason this matters commercially is because employees who align with organizational values are less likely to cause you issues, because they're more likely to integrate successfully with teams, respond positively to management feedback, or to management instruction, are able to contribute positively within the workplace culture, and then in turn remain within that organization long term. And from a legal perspective, those factors become incredibly important under the new reforms, under the new ERA 25, because when employers need to manage concerns, it becomes much easier to evidence those clear expectations and the behavioral standards and the management processes. So one thing we often say to our employers is, yes, skills can often be trained. Attitudes and behaviours are usually much harder to change because they're just ingrained in that person, instilled in that person. So organisations need to have a think about that recruitment process genuinely. Does it genuinely assess those behaviours and values of your organisation? Or whether those interviews focus almost entirely on the technical part. And I'm sure you don't do that, but it's just something to bear in mind, that they really do need to come hand in hand, and it's not just about those technical skills. Okay. So this slide is about defining organisational values clearly, okay? And it's really about helping organisations move from vague ideas about cultures and values into something which is much clearer, more measurable and more manageable. So you'll hear a lot of employers and organisations talk about their culture, but when you ask managers what behaviours are actually expected here, the answers can quite often be inconsistent, and they're not living by those values of the company. So under the Employment Rights Act framework, the lack of clarity around your values can become problematic, because if an employer or if employers are going to rely on behavioural concerns during probation or performance management processes, they need to be able to clearly demonstrate what standards were expected, how were those standards communicated, and where the employee fell short. So organisations need to define their values in a much more practical and operational way. So what does this mean? This means identifying what behaviours are expected day to day, what good culture actually looks like in practice, how managers are expected to lead, and what standards of communication and professionalism apply across the organisation. So I suppose what I'm saying importantly is that values should not just simply sit on your website, on the office wall. I mean, at Bhayani Law, we have them everywhere. We have them on our mouse mats, so we're just constantly able to see them. And we need to kind of translate these values into kind of observational behaviours or observable behaviours, should I say. So, for example, if an organisation says it values accountability, what does this actually mean in practice? So does it mean taking ownership of mistakes, responding promptly, meeting deadlines? What does it mean? Something that we do at Bhayani Law when we have our PDRs, our professional development reviews, is that we have a section on how we are living by our values, how we are working to our values, what have we done in the last quarter to align with the values of Bhayani Law. And so we're constantly getting that, it's constantly in the forefront of our mind, because our values are close to our heart. So if collaboration is a core value, for example, employers should be able to explain what effective team work looks like, how employees are expected to communicate, and what behaviour undermines collaboration. And the reason this matters is because behavioural expectations become much easier to manage fairly when they're clearly defined. Another really important thing to note is that managers themselves need to model the behaviours the organisation expects, because obviously if you're kind of looking up to your manager and they're not living by or working by the values, then how on earth is that employee expected to work by the values? So ultimately, under the new reforms, employers who define and communicate organisation values effectively are going to be in a much stronger position to recruit successfully. And that's the point, and manage that performance fairly, and defend decisions where concerns arise later. Okay, so this is about recruitment and probation and how they really must go hand in hand. Okay, it's something that employers often overlook. And it's important to note, isn't it, that recruitment doesn't end when that candidate accepts the job. In many organisations, what we still see is there's a heavy focus on that recruitment process itself, advertising the role, interviewing candidates, selecting the preferred applicant. And once that offer is accepted, the structure often falls away. But under the ERA reforms, that approach is becoming increasingly risky, because I suppose onboarding and probation are no longer kind of simply administrative processes. They become critical stages in reinforcing those expectations, identifying concerns early, supporting employees appropriately, and evidencing fairness if issues arise later. So in practical terms, recruitment, onboarding, probation should operate as one continuous process. So the recruitment stage establishes what the organisation is looking for, the behaviours expected, the standards required, and then the onboarding and probation processes can reinforce those expectations that, consistently from day one. One of the biggest mistakes we see is that employers assuming that employees automatically understand what good performance looks like within the organisation. If you change workplaces and go from one organisation to the other, that's likely to look different. What good performance looks like. So because we know that workplaces operate differently. So employees need clarity around their priorities, the communication expectations, the reporting lines, the professional standards, and how that success in the company is going to be measured. And this is why structured onboarding is becoming increasingly important. So a strong induction process helps an employee understands their role, what support is available, what standards apply, and how performance will be reviewed. And this also creates a much stronger evidence, or it just creates much stronger evidence that expectations were communicated clearly from the outset. So you're going to be documenting that, so that if you're challenged later, you can say, look, this is what was expected. We really made it clear to this employee. Here's the evidence to show it, and they didn't succeed in achieving those standards. So another key area here is objective setting. So employers shouldn't wait several months before discussing performance expectations. Okay, so managers should establish measurable objectives early on in employment so that employees understand what they're expected to achieve, how progress will be assessed, and where improvement may be needed. Regular probation reviews are equally important, and we're going to go on to that in a little bit more detail. One issue that we frequently see in probationary periods is that it's being left unmanaged until the final weeks, and they think, actually this person is not up to the job, so we're just going to dismiss. This can't happen anymore, basically, because you're just going to come unstuck. And importantly, feedback should not only arise when something goes wrong. Excuse me. Employees perform much better when managers provide that ongoing guidance, that reassurance, that coaching, that support, a clear direction throughout that probationary period. And if you're doing those things, then you're not going to be challenged, or you're going to have a lot of evidence on your side to show you did everything to get that employee to where they needed to be as quickly as possible. So managing probationary periods effectively. Again, really important slide for you to take note of, probably the most important one in the entire session. Historically, we know that many organisations have treated probationary periods as, in quite a passive way. Often the probationary period exists in the contract, but in reality, we're not having those probationary meetings. There's very few structured reviews. Concerns aren't addressed early. Those difficult conversations are delayed until the very end of the process. One of the key things that needs to be done in light of these changes is that, having those difficult conversations early on, I know they feel awful, but you just need to have them, because you're giving that employee the opportunity to improve earlier on. And that approach that I've just discussed is obviously going to be quite dangerous under the Employment Rights Act, without those structured reviews, without those concerns being addressed. It really does potentially cause issues. So because with earlier unfair dismissal protection and increased scrutiny around probationary periods, employers will need to demonstrate that probation was actively and fairly managed. So in practice, that really means that employers can no longer kind of afford to leave those concerns unresolved, like we've just said. And one of the biggest risks we see is where concerns arise early, but managers hope that things will improve naturally. They bury their head a little bit. Feedback is maybe neutral. Feedback is vague. Feedback is inconsistent, and formal conversations only happen shortly before dismissal. If that happens, and that's how you're operating your organisation, you're exposing yourself to risk, because you'll struggle to evidence, if this went to tribunal, what expectations were clear, what concerns were communicated, or that the employee had a fair opportunity to improve. So the key implication for employer is that probation management must be proactive as opposed to reactive. And to be honest, I feel that's probably the best piece of advice I can give you. It's just about being proactive in this situation. So we need to identify those concerns promptly. So spotting those issues early, gathering those objective examples, addressing concerns when they first emerge, not just several months later. And importantly, feedback needs to be immediate and it needs to be constructive. Those are the difficult conversations that I'm referring to. And one of the worst things employers can do is to give consistently positive or neutral feedback during the probation, because they just don't want to be, a bit of a baddie, a meanie, and then suddenly, they raise a serious concern at the end. That's just not fair on the employee. It's not the way to address it. If there's an issue, it needs to be addressed then and there. Because if we do that and we leave it to the last minute, it's creating obviously both that legal risk and employee relation problems, because employees can legitimately argue that they were never made aware of that issue. So regular probationary review meetings are therefore essential. So those meetings shouldn't just be kind of an administrative tick box exercise. They should genuinely discuss the performance, the objectives, the behaviours, the support needs, progress, and any other concerns. And where concerns exist, managers should communicate them clearly and professional. So what that means is it's about being specific. It's about using examples. It's not about being vague, explaining the impact of the issue on X, Y, and Z, and outlining improvement that is expected. So being specific with those examples so that employee can really understand where they're going wrong. So if we're being ambiguous and we're giving feedback such as, it's just your attitude, or you need to improve your attitude, or you just need to be a little bit more proactive, comments like this are rarely helpful, because employers don't really understand what that actually means. It's really important that clarity is crucial. We also, and I always say these in this session, that documentations is also key. So employers need to be recording, those review meetings. Please write it down, especially in light of these reforms, because, we always say here at Bhayani Law, if it's not written down, it didn't happen. And we can't really stress that enough. So when you're having these probationary reviews with your employees, make sure that you are documenting any concerns raised, any support provided, any objectives agreed, and following up with actions. Make sure you've got that documentation, so that, because if later down the line, you get an unfair dismissal and this is challenged, you'll be able to show that you were doing everything you can to manage that person during that probationary period. All right, so one of the key themes throughout today's session is that probationary periods need to become an active management process rather than kind of passive timelines. Okay, so many organisations currently have probationary clauses in the contract, and like I've said, they have very little structure around how they're actually being managed in practice. So under the new reforms that are coming in, this creates a significant risk, as we've already touched upon. So what we're suggesting here is there needs to be a more structured, evidence-based approach, starting with week 1. Okay, so we get them in, we're onboarding, we're doing an induction, we're setting those objectives there. so it's clear. So employees should understand what success looks like in that role, what behaviours are expected, how performance will be measured, and what support is available. So this is the point that you might be ensuring that the job responsibilities and duties are clear, that they know the reporting lines are clearly understood, and the employees know how probation periods will operate. The next stage is kind of an early on review. It may be around month 2. And this is important because it creates an opportunity to identify any concerns. I know after 8 weeks, you don't really have a clue as to how somebody's going to work out. I get it, but we just need to be documenting it anyway. So you're looking to see whether there's any concerns there early on. And we're not waiting for the kind of formal probation reviews for concerns to arise. If we see an issue arising prior to that, then we need to be giving that feedback. Feedback should be ongoing all the time. Then we're going to move into a more formal review, maybe around month 4. This is particularly important with the 6-month qualifying period framework, because effectively what we're doing is we're making sure we're putting our probation reviews within a much shorter period, so that when it comes to just before the 6 months, and bear in mind their notice, you have got, you can dismiss fairly, and it's not spilling into that. It's not going past the 6 months. So we're going to have that formal stage 2 around 4 months. One issue we often see is that employers are raising concerns too late. So, sometimes a week or 2 before probation. Well, that can't happen now, because we need to be making sure that we're following that fair process and probation reviews. And the final probationary assessment before kind of the 6-month period is crucial. And again, just factoring in that notice period, so they can't argue that actually, had my notice been included, I would have had over 6 months service. It's really important that this is where you're bringing it all together. Employers who fail to actively manage probations are going to later struggle, obviously, to justify the decisions. So it's really important that we're bearing in mind our probationary periods. And obviously, in turn, that's going to mean you're going to need to update your policies so that it's clear. One of the biggest problems in tribunal claims is the inconsistency between what employers say later and what actually was communicated to that employee at the time. So if we're looking at those records again, if those records show positive feedback throughout the probation and then suddenly dismissal at the end, that's likely going to attract a fair bit of scrutiny from the tribunal from a fairness perspective. And I'm going to talk again about documentation and record keeping. Like I said to you, it's super, super key that we just are documenting everything. And I really can't say that enough. Ensuring that your managers record carefully their reasons for dismissing, and keeping their notes, getting into the habit of taking statements from key witnesses at an early stage, training your managers on what good documentation looks like, and creating kind of internal processes that help respond to claims quickly and consistently. One thing I just want to touch upon here is currently most claims such as unfair dismissal must be brought within 3 months less 1 day from the relevant act, so from dismissal. This is going to be extended to 6 months. So effectively what that means is it's giving the employee a longer window to bring that claim, which in turn leads to an increase in the number of claims filed. Employers need to be prepared for this change by ensuring that, so what I'm trying to say is that if we document it at the time, we've got it and it's fresh, it's there for us to refer back to. With this delay of tribunal claims actually landing on your desk, memories fade, etc. So it's really important that we have that written down, that stage, so we can refer back to it when those memories are feeling, are slipping a little bit. All right, so that was all from me for now. So I am going to pass over to Hasti, who is going to take over now.
Yes. Right. I can see the poll. Hi, everyone. So we've just got another poll on the screen. If you could all just pop your answers in. So what is the biggest barrier to managing poor performance early? What do you think that could be, maybe within your organisation? Do you feel that managers maybe try to avoid difficult conversations? There might be a lack of HR support. maybe lack of documentation or fear of grievances or claims, or time pressures. Let's have a look. Okay, so lack of documentation, time pressures, and managers avoiding difficult conversations. I think managers avoiding difficult conversations is the most voted one, and it's probably the one that we see the most as well, which is why that training for managers is so important, because it allows them to learn how to navigate these conversations. And if you address it earlier on, it just avoids claims and further issues later on down the line. So next slide, please, Alex. Thank you. Okay, so we're just looking at what causes employees to underperform, because it's not necessarily just about capability or if they've got gaps in knowledge, etc. Sometimes it's personal circumstances, organizational factors, or maybe also management issues. So as employers prepare for the change to the unfair dismissal qualifying period, it's really important to be able to identify what the root cause of the underperformance is, to then be able to address it accordingly. So the most common ones that I think we see is lack of skills. So sometimes employees simply don't yet have the technical knowledge or skills or experience needed to do the role. And this is often a capability issue rather than a conduct issue, and it requires support, coaching, maybe more training, development. Vague expectations. So if expectations are clear from the start, employees can unclear from the start, sorry, employees might struggle to understand what success would look like within your organization. So it's important to define objectives clearly, making sure that there's consistent communication, consistent objectives, and feedback, and that feedback is constructive and not necessarily just critical. Job dissatisfaction. So when employees feel disengaged or undervalued, disconnected from work, and that naturally just declines their motivation. So this can show up as reduced productivity, lower quality of work, or a lack of initiative. Then we go on to poor workplace culture. So, a negative culture can significantly impact performance. Environments where there's low trust, poor communication, maybe favoritism, bullying, and they feel uncomfortable. It reduces morale across the team and it creates disengagement, which ultimately impacts performance. Stressful working environment, so excessive workloads, unrealistic deadlines, or constant pressures which lead to burnout. And of course, we see a lot of people going off sick for stress, work related stress, poor relationship with managers. The relationship between a manager and their employee is one of the biggest influences on performance. If they feel that there might be a lack of support, inconsistent management, poor communication, or that they feel they can't comfortably speak to their manager, they can't raise any conflicts if they've got any, or any concerns, that can also impact performance. Inadequate training, so that links back to the lack of skills, I suppose, because again, they just need a bit more support in order to be able to do their role. Without proper development, opportunities and performance can stagnate. Lack of variety or challenge, if work becomes a repetitive task, employees feel that there's no opportunities to grow, and then that means that their motivation might decline over time. Insufficient onboarding, I think that links back to a lot of what Alex has been saying earlier on in her slide. So making sure that their values align with the organization's values, and that in the earlier months of employment, it's the critical time to make sure that the relationship is there, and there's clear expectations, there's a clear system, they're aware of what the company culture is, and they know how to get support if they need that support. And if them problems aren't addressed earlier on, it can affect their performance moving forward. Personal issues. So sometimes underperformance isn't actually about work or about their skills or what they can and can't do. It might be life at home, it might be something else, it might be their health that can be having an impact on them. And also Oh, I think that was the last one, wasn't it? Yeah. So the key takeaway is that effective performance management is not just addressing poor performance, but it's identifying the causes early and being able to address them to prevent the escalation moving forward. Thanks. So managing poor performance from day one. So again, we're looking at it right from the start, because it's no longer optional. It is now essential. So the focus there is that the focus is shifting from reactive performance management to proactive performance management. Employers can not afford to allow concerns to drift or remain undocumented during probationary periods or the earlier stages of employment. So again, the documentation is really, really important. If issues do arise, they need to be identified and managed promptly. So a critical starting point is ensuring that employees clearly understand what is expected from them, what success looks like within the organisation, and how is their performance measured, what support is available to them to help them improve and succeed, and also for the employer to be able to demonstrate transparency from the start. So if there are any concerns, speaking about it from the start rather than letting it escalate and then looking at maybe a dismissal. So it's good management practice, and it does show procedural fairness if a claim did land. So tribunals will increasingly expect employers to show that they have communicated standards clearly, gave employees a reasonable opportunity to improve, provided support and feedback, and followed a fair and consistent process throughout. So this isn't just something managers can do for one individual, and maybe let it slide for someone else. It's something that they would have to do across the board for everybody. Line managers are often the first person to identify performance concerns. So organizations need to ensure that managers are properly trained and confident in having them difficult conversations, identifying issues early, giving constructive feedback, gathering evidence and documenting it where needed, and applying policies consistently. So if we aren't doing things like this, there is a risk of getting it wrong, and that's when it can lead to the unfair dismissal claims, potentially discrimination claims, if we're not doing the same thing for everyone. It creates that employee relation breakdown, and it might have an increased turnover and low morale across the workforce. So informal performance management. When we talk about performance management, I think everybody automatically thinks it's a formal process and it's going to lead to a dismissal, but it's important to recognise that it can be addressed informally first. And I think that would be the best action to take. So before problems escalate into formal capability or disciplinary procedures, it can be dealt with as part of day-to-day management. And often employees are not aware that there is an issue with their performance until it's actually raised with them. So a timely and supportive conversation can frequently resolve concerns without the need for formal action being taken. So a good informal discussion should cover things like examples of where standards were not met. So specific examples rather than generally criticizing them and their work, making sure that it's a constructive conversation and it's professional, and the feedback that you are giving is something that they can work on. Agreeing clear next steps and following up in writing where appropriate. Managers should give employees the opportunity to explain whether there are underlying issues affecting their performance. So, such as the issues we discussed just at the start of when I took over. If there's something going on at home, is it that they've got unclear expectations? There might be an issue with workload, well-being concerns, addressing if there's any sort of culture concerns within the workplace, and also making sure that these factors are addressed earlier on to prevent further deterioration of the performance and also the relationship. Although it is only an informal process, it's really important that you're still making notes and that you're keeping these notes and agreed action. So brief notes of the conversation, whatever it is that you've agreed moving forward. And this demonstrates consistency and fairness when a formal procedure does arise, if it does arise, and any record at this stage would not form part of any disciplinary record. It is solely just to make sure that you've got it for the employer's purposes. So now moving to formal performance management. So whilst informal performance management can be highly effective, some employees might need it to move to a formal process instead. And this typically happens where performance is not improved despite several informal conversations. You've already provided the support, you've already given the feedback, and they're still not quite there yet. Maybe it's that the concerns are more serious in nature and they do need to be addressed formally in the first instance, or that there's a continued failure to meet the required standards. So the key point is that it's important to recognise when informal management is no longer sufficient and when a structured formal process is necessary. So a formal performance management process provides a clear structure, it's got defined expectations. This information, when it is documented, can form part of disciplinary capability, documentation, and procedural fairness for both the employer and the employee. So before moving into a formal process, employers should ensure that expectations were previously communicated clearly. The employee had a reasonable opportunity to improve, and appropriate support and training was offered where needed. And once the formal process begins, consistency and fairness becomes absolutely critical. So employees should be informed clearly of what the concerns are, the evidence supporting these concerns. So if you've received negative feedback from somebody, if you've got documentation that you've sent them emails multiple times saying you need to be doing this, or you've given them feedback and they've not worked on it, the standards expected from them moving forward, and the potential consequences if improvement is not achieved. So the process should also include measurable objectives, and with realistic timescales for improvement. Vague expectations can create confusion and increase legal risk, particularly under the new unfair dismissal framework, because you've only got that 6-month window to make sure that you're doing everything right, or that they are the right person. You're opening yourself up to that risk. Regular review meetings are important throughout the formal process, and these meetings allow the manager to monitor the progress, provide any feedback if required, discuss any obstacles, and assess whether sufficient improvement is being made. Importantly, the process should remain supportive rather than being purely critical. And the goal of a performance management should always be improvement where possible. And again, documentation is another key element of this process. So you'd need to be maintaining records of meeting notes, improvement plans, any targets that have been set, any support that's been offered, outcomes if discussed, and if a dismissal decision is ultimately made, these records may become essential when you're trying to defend an unfair dismissal claim should one land. So supporting employees to improve, performance management should not simply be about identifying problems or moving towards dismissal. As I mentioned, the primary objective is to try and allow that individual to improve and reach the standard required of them. So tribunals will also expect employers to demonstrate that the reasonable support was provided before formal action was taken. And the first step in supporting improvement is identifying the root cause of the performance issue. So poor performance is not always capability alone, as we discussed. So it might be lack of training, unclear expectations, workload pressure, personal circumstances, health and well-being, insufficient resources or supervision. And sometimes it might just be that, again, they don't have that good relationship with their manager. They don't feel comfortable discussing with them if they are struggling. So making sure that the manager has openness and they are approachable so that they can have these conversations with them. And it's important that the manager isn't making assumptions before hearing what the individual has to say. So once the issues are identified, employers should consider what practical support can be offered. So this might look like maybe training, mentoring, clearer objectives, more regular check-ins, adjusted workloads, more guidance, or additional supervision and feedback if that's what they're requiring. So the support should be tailored to the individual and not necessarily to the role alone. Clear communication is also essential throughout this process. So employees need to understand what improvements are required, what that success will be measured and how it will be measured, and what it would look like, the time frame that that improvement needs to be made within, and what support is available to them to help them achieve these goals. Employees are far more likely to improve when expectations are specific, achievable, and clearly communicated. So, regular review meetings also play a key role. These meetings should be simple and focus on shortcomings and also to acknowledge any progress, and allow that individual to open up if there is anything that they need to discuss. Constructive feedback can help maintain engagement and motivation during what can be a very stressful time. So employers should also be mindful of their legal obligations, not just necessarily the work ones. So making sure that it might not necessarily be linked to a disability or health condition, because if that individual does have a disability that might take a toll on their work, on their productivity, for example, you might need to consider reasonable adjustments to ensure that you are complying with equality obligations. Documentation, again, remains very important. So making sure that you're documenting these conversations if you're having them, any support offered, if you've offered them to make a reasonable adjustment or you've offered occupational health assessments, making sure that these are all recorded, review discussions and any progress that's been made over time. So the key legal risk here is failure to provide any support may undermine the fairness of any later dismissal. So should the informal and formal performance management not lead to improvements, or if the employee is still failing to meet the required objectives, then a capability process might commence. The employee should be invited to a formal capability meeting in writing, and the invitation should clearly set out the date, time, location of the meeting, the performance concerns being discussed, the reason for these concerns, and that the meeting is being held under the capability policy and referring back to the policy or providing it if necessary. It's also important that the employees understand exactly what the concerns are, and any relevant documents that will be referred to during the meeting should also be provided in advance. So this would just allow them the fair opportunity to prepare and respond. If they know what you're looking at, they might be able to answer your questions better if they've had the opportunity to review it beforehand. The letter should also explain the potential outcome of the meeting, such as an improvement plan, a formal warning, or any other formal action. Employees should also be informed of their right to be accompanied by either a trade union representative or a workplace colleague. And providing clear information in advance helps ensure the process is fair, transparent, and compliant. And finally, the formal performance review meeting under the capability policy will usually be conducted by the employee's manager. And the purpose of this meeting is to discuss the performance concerns formally, whilst also giving the employee a fair opportunity to respond. So again, this is why it's really important to make sure that the managers are trained enough to have these difficult conversations, because in the first instance, it will be them that will be conducting these meetings. At the meeting, the manager should clearly explain the standards expected of the employee, the areas where those standards are not necessarily being met, and the evidence that they have to support these concerns. This could include example of missed targets, quality concerns, previous discussions about performance. So any of the meeting notes that you've had for the formal discussions, you'd be able to use. And importantly, the meeting should be a two-way discussion. So the employee should have the opportunity to ask questions, respond to the concerns raised. So that's why they have the documentation in advance to prepare for this and provide their own evidence if they have any, and explain any factors that might be affecting their performance, so mitigating factors. Part of the discussion should focus on identifying the underlying reasons for the poor performance. So could it be training? Could it be that they have a lot on in terms of workload? Do they need more support? Are they struggling with their health and well-being? Are they not sure what you're actually asking of them? So it's about having these discussions and focusing on improvement and support. Managers should discuss what steps can be taken to help the employee improve. So if it is maybe their health and well-being, seeing whether they need an occupational health assessment, whether they require additional training, whether they need more feedback, more touch points, or regular supervision. And finally, the meeting should conclude with clear improvement targets and a realistic timescale. The employee should leave the meeting understanding what is required of them, what they might not necessarily be doing quite correctly, what success looks like and how it's measured, and what support will be available to them if they need it.
Perfect. Thank you very much, Hasti. That was fabulous. So we're at 1 o'clock, so we are nearly at time, but we've probably got time for a couple of questions if anybody has any. Anybody got any questions? If not, you can always send your questions separately to us over email. That's also absolutely fine. Yeah, can't see any questions coming in.
No.
You know where we are if you have some. You've been monitoring the chat box.
We had no questions, but I think we've got 2 now.
Wonderful.
Extending this to 6 months. So one is on probationary periods. I feel like this would be good to just say in case anybody else would want to also know. So they've put, our current probationary periods are 3 months. Would you say it's worth us thinking about extending this to 6 months? I mean, it's up to the organisation, but because at that 6-month point, the individual's right for unfair dismissal sort of starts, I feel that probationary period needs to maybe end prior to that to allow some wiggle room for an extension if required. Now, I don't know, Alex, if you've got anything different or
absolutely. I would agree with that. I think, if your probationary period is only 3 months as it is, my advice would be that you need to be factoring in a few more reviews within that probationary period, even extending it a little bit, so that there's time so that there's time to carry out those processes and those reviews as much as you can, because ultimately 3 months isn't very long to be able to suss out whether somebody's a decent employee. You really need to get to know whether they are a decent employee and they are going to be somebody that you want to retain, and the only way you're going to do that is by having more reviews with them. So my advice would be, yes, to amend that slightly if I were you. Do you want to do one more, Hasti, because I'm just conscious of the time?
Yes. So, I mean, we've only got 2 more questions. One of them is, can you advise that what we would need to be aware of in terms of fixed term workers? We have a number of year out students. Again, I would say that what we've discussed today still applies to them individuals. If their contract is greater than that 6-month period, they would still be covered with the same things, unless you want to give them shorter contracts. But yeah, so if they meet that 6-month threshold, these steps that we discussed today, I'd say, are just as important, regardless of what type of contract they're on.
Yeah, agreed.
And then one more, how would sickness work within the policy? If a member was off on long-term sick during the 6 month, would that extend, or would that be extended, or would the sickness time be included?
Would that be extended, or would the sickness time be included?
So I think probationary wise, I suppose some people put it in their contract to have it extended, but legally it doesn't. The sickness isn't. Yeah, exactly. It doesn't take that into consideration. If they've been employed for that long, they've been employed for that long.
The main consideration there is you would just be really, really, really cautious, because if somebody's on long-term sickness, they're likely to have potentially be protected by the Equality Act, from a disability angle. So I would be really, exercising some caution when you're approaching that situation, and maybe speak to us directly about that, because you don't want is a disability discrimination claim landing on your desk. All right, so that's it from us. Let me just go back to my screen and just finish off with a couple of slides. You gone? Right, so so if you want to receive a copy of the slides today, that's absolutely fine, but we would ask that you just provide some feedback forms, or respond or fill out our feedback forms, which will be sent to you after the webinar. And please feel free to leave us a review on either Google, Trustpilot, or Review Solicitors. It would be greatly appreciated. Just a little summary of the training and events that are coming up. So at the minute, next week, in a week's time, we're going to be running an Employment Rights Act 25 training for managers training. If you would like to book onto this, please absolutely feel free. I'm going to go on to it into the next slide and tell you a little bit more about it. We've also got a sexual harassment training on the 3rd of June, which please feel free to book in. A sexual harassment training half day on the 17th of June, and obviously our social Bhayani summer barbecue, which we're very much looking forward to, and all money goes to towards the Western Park Cancer Charity. So if you are interested in this session on the 27th of May, please do go ahead and scan the QR code now. We can also come into your office if that's easier and provide it to the team, as opposed to doing it online if that's what you prefer. So if you are interested, please get in touch. It's a really helpful training. We've had a lot of good positive feedback from it so far. We also have access to the ER planner, and we are offering a comprehensive audit in line with the Employment Rights Act. Again, if you're interested, please have a scan of the QR code. Both the Bhayani Law both of these are on our website, and you'll find some free resources on there as well. Please have a little look. It's always up to date, so it's a really good place to start. So yes, feel free to scan that if you'd like. Just a little bit about how we can help you. We offer the watertight packages and the legal support, which we touched upon earlier. But thank you all for joining us all today. I really, really hope that you got something valuable from that. Any questions, please do follow up. We're more than happy to help. And yeah, look forward to seeing you all next time, I hope. Okay, take care. Have a